Did you know that in the state of California, you can be held liable for a criminal act, even if you were not directly involved in it? My name is William Pernik. I'm a criminal defense attorney and a certified specialist in criminal law. Here with me is my friend and my partner, Roland Soltes, who is a very experienced trial lawyer. And in today's video, Roland and I will cover some significant topics related to accomplice liability and even share some of the war stories and case examples to illustrate how accomplice liability in California works. So we're going to cover a lot of ground. Buckle in, hold on to the edge of your seat, and let's get started. So Roland, for purposes of our discussion today, I wanted to introduce our viewers to the notion of accomplice liability. I think a lot of people understand intuitively that when a person commits a crime, there are consequences that follow their direct involvement. But what a lot of people, I think, may not realize is that in our state, in California, a person can be held liable even if they did not directly involve themselves in a crime.
That's correct. I mean, somebody has to be involved in the planning of a crime for a conspiracy to be, and then part of that conspiracy they have to do what's called an overt act, which is typically something that just furthers the conspiracy along.
And conspiracy is one of the first legal doctrines we're going to cover because it deals with planning to commit a crime by two or more individuals. A person can be liable for the criminal act committed by a fellow conspirator, or as we call it, co-conspirator, and a person may be held liable for acts by others that they weren't even aware of, so long as those acts promoted the overall objective of the conspiracy.
Yeah.
Separate from conspiracy liability, which again deals with what happens when people plan to commit a crime, whether or not the crime actually occurs, there is a secondary doctrine of aider and abettor liability. And in this type of liability, we're dealing with participation in the crime itself. So can you tell us what is the difference between a principal and an accomplice in this scenario?
Well, I mean, we'll use a classic term, somebody that's robbing a bank. A principal would be somebody that just walked in and robbed the bank. They went to the teller, they went to the window with a gun, said, "Give me all your money," and they got the money. Where an accomplice could be somebody that was either involved in the preparation of it, they could be outside, they're doing something to assist the main participant in their crime that they're committing. It doesn't necessarily have to be directly involved in the actual crime, but they're doing something that allows that person to commit a crime. I had a case of bank robbers years ago where I represented the makeup artist that took these gentlemen, put female makeup on them and put wigs on them ahead of time. So she got charged with accomplice liability for the bank robbery. She really should have been charged for the horrible makeup job she did. But but that's a classic example of an accomplice that wasn't actively involved.
And so with aider and abettor liability under California law, even if you are not the principal actor, but you're somebody who's assisting the principal by either aiding, abetting, encouraging, or facilitating the commission of the crime while sharing the intent of the principal actor, you will be held just as liable as the person in Roland's example who is holding the gun or passing the note to the teller, even if all you were doing is scouting the place, acting as a lookout, or putting on really bad disguise and manufacturing awful-looking wigs, Roland, in your example. And then the third concept we're going to talk about today is something that I think some people do have an understanding of, which is accessory after the fact.
Oh, yes.
Accessory after the fact, for example, if you call your friend, you call your loved ones, you ask him to give you a lift from the crime scene, they can be charged as accessories after the fact. If a person helps you hide evidence of the crime, helps you conceal or repair, for example, damage to the vehicle, bullet holes to the vehicle.
And we've had that.
And we have had that, and we'll talk about it today. But if somebody helps you conceal evidence, hide evidence, or harbors a fugitive, those people can be held liable under the theory of being accessories after the fact. Importantly, they're not liable for the original crime. They're only liable for their specific role in this scheme, which is the last chapter of the criminal conduct.
Yes.
So with that in mind, let's begin by talking about a conspiracy. Conspiracy is defined as an agreement between two or more individuals who jointly agree to commit a crime. That crime is considered the target of the conspiracy or the target offense. Conspiracy can consist of just two people. Roland and I can agree to go and rob the bank. But conspiracy could also involve many individuals, and not every member of the conspiracy, Roland, needs to be aware of everybody else, correct?
That's correct. You only have to be aware that there's another person that's involved in the planning, and you're taking an overt step towards that conspiracy.
The overt step requirement is very important because this is what separates ideas from actual execution, planning from fantasy. So if, for example, Roland, you and I talk about robbing a bank, you and I could joke about doing it, we can fantasize about it, we can ask ChatGPT 57 questions about different ways that banks get robbed, but what it would be the example of an overt act that would transform this fantasy discussion into an actual criminal conspiracy?
Well, I would say if I went down the street and I started casing the bank, drawing diagrams, looking for information, anything that furthers my ability to carry out the crime. It doesn't have to be that significant. I think in the future we're going to even see people that are getting steps where you go to ChatGPT and say, what are the 8 steps I need to rob, Bank of America or something of that nature, and give a specific location. And maybe ChatGPT will say that location is at this and the getaway is this. I mean, who knows what this artificial intelligence will do, but even that could be considered an overt step.
A person can withdraw from a conspiracy if and only if they indicate by words or conduct that they're actually done, they no longer wish to participate in a conspiracy, and they're effectively withdrawing. If a person withdraws from the conspiracy and the criminal act occurs after the person has indicated by words and conduct, or by words or conduct, that they're withdrawing, then they're no longer held liable for that act that happens after they withdrew.
Yeah, and it has to be unequivocal. I mean, everybody has to be aware that you are out, that you are no longer involved in this conspiracy. It can't just be that you just don't show up to whatever they're doing. You have to actually tell everybody that you're out, and it has to be clear.
Another really good example of a conspiracy would be a murder for hire plot, because in a murder for hire plot, you could have a spouse who is contracting an assassin to murder the other spouse. The assassin does not actually need to be serious about carrying on the crime, and most of the time, these guys turn out to be police officers who are, acting as decoys online, because law enforcement really likes to target criminal conspiracies. In a police manual of operations, solving a conspiracy is the best possible resolution you could have, because you're capturing a person before they can victimize someone else. So they really like prioritizing law enforcement resources. And obviously, if there is a murder for hire plot going on, a police officer could pose as the assassin. And as soon as the husband takes an overt act, for example, wiring the money, they can be arrested and they will be charged with a conspiracy to commit murder. And the penalty for committing a conspiracy is the same as the penalty for the target offense, with some exceptions being that a conspiracy to commit a misdemeanor is still considered to be a felony. Now, we just talked about criminal conspiracies, which again cover agreement to commit a crime before the crime ever happens. In order for conspiracy to commit a crime to be successful, crime need not occur. Just like in a murder for hire plot example, the husband does not need to actually see the spouse dead. It's enough to wire the money and have an agreement with the assassin to do so in order to be guilty. But let's talk, Roland, about a different type of accomplice liability. This time one that happens during the commission of a crime. I know you do a lot of gang cases, so do I, and so we see that a lot in circumstances where you have a car full of, let's say, young adults. They go on a mission in, let's say, in a gang context, reconnaissance mission in the enemy territory. The idea is that the first person of the opposite color that we see, we're going to shoot. Walk us through aider and abettor liability in this scenario.
Well, in a scenario like that, everybody that's in the vehicle is considered an aider and abettor, because you have, number one, if you're going in the car and you're driving to some place, there is some type of agreement to commit a crime. Depending on what the crime is, if it's to shoot somebody, then you could be charged with murder if that person's killed, because it's such an act that's so dangerous to human life that anybody would know that somebody could die from that. So you would have ill intent when you're doing that. But an aider and abettor could be somebody that's in the back seat that hands a gun to somebody in the front seat. It could be somebody just sitting in the back seat because the person in the front seat knows that if something happens and trouble happens, that he's got a
muscle
backup in the back seat. Exactly. It's the proverbial old muscle where you have two big guys that are there. And so that's an aider and abettor. The person that's driving the car is an aider and abettor. The person that's looking for the cops on the other side is an aider and abettor. So anything that you do that helps facilitate the target offense, which is shooting at, a red or a blue or a green, however you want to look at it, that is an aider and abetter.
And so this creates a circumstance where a person who is driving the car, who never picks up a gun, never fires a gun, never directly kills anyone, could be just as liable for murder as the shotgun rider who actually is the one doing the shooting and the execution. There are some exceptions to this rule. Obviously, we've had some cases where drivers were asked to give somebody a ride. Suddenly, a person would brandish a pistol and fire a shot. If the driver does not share the intent of the shooter, if the driver is unaware of what's going on, if the passenger in the back is high or drunk or is busy looking at his phone and is not aware of what's about to go down, then there would not be an aider and abetter liability. But the law defines aider and abetter liability as follows. If you are present at the scene and in addition to being present, you aid, abet, or facilitate the commission of the crime by another while sharing their criminal intent, you will be liable for the same exact act as a principal. Mere presence at the scene is not enough. It's the sharing of the intent and doing something to show that you want the same exact outcome, that you want to see the person dead, that you want to see the bank robbed, that you want to see the crime succeed. And it gets dangerous in some circumstances, including cases on school grounds, Roland, because how often do we see cases where kids have fights
and everybody jumps in?
Everybody jumps in, or you have a couple of people who are standing back. They're not breaking up the fight, but what are they saying? They're saying, oh, hit that fool. Yeah, they're egging it on.
Or videotaping it?
They're videotaping it. Although videotaping, I don't know if that would be considered aiding and abetting, but I think
it depends on if you're videotaping and egging it on.
Yeah, if you're
just videotaping wouldn't be enough.
If you're videotaping and annotating by saying, kick that fool, punch that fool, things of that nature, then yes, you're definitely risking it. And then the last part of accomplice liability is accessory after the fact.
Yes.
So in the example of a gang shooting, somebody calling their friend afterwards saying, hey, I need your help, come pick me up, I was involved in something, that's accessory after the fact. Taking a car that has bullet holes in it and getting it fixed, that's accessory after the fact. Hiding the gun, concealing the fugitive, all of those things that help somebody get away with the crime, all of those things are considered to be accessory after the fact type conduct, and it carries significant liability with it.
And we've had many cases with all of those examples.
Exactly.
So, William, a couple of years ago, you did a murder trial that pretty much dealt with all of the topics we've talked about so far. Aider and abetter, conspiracy, and accessory after the fact, just depending upon how you looked at it. That was a murder that was in northern Monterey County with 3 different people involved. Can you run us through that a little bit?
Yeah, that's very interesting that you brought it up because the case did cover pretty much every theory of liability we discussed today. And what happened in that specific case, People versus Sandoval, is that my client, who, by the way, I believe was completely innocent of murder, was charged together with 2 of his friends, Mr. Beltran and Mr. Alcaraz. Mr. Beltran and Mr. Alcaraz were friends of my client. They have known each other through high school and young adulthood. Beltran formed a plan to rob his former employer, Taco Bell, and he agreed with Alcaraz that they were going to do it. My client was a little bit differently situated. He was somewhat socially awkward. He had some mental health background-related issues that made it harder for him to perceive and truly appreciate what was going on around him. But after a party, Beltran and Alcaraz basically got dressed, got armed, and asked my client to give him a ride to the scene of eventual murder. They went inside the store after hours. They were allowed in because Beltran used to work there at some point, and they proceeded to beat really, really badly the manager of the store, and Beltran ended up taking one of the employees into the back of the store and slashed his throat. When they came back from the store, covered in blood and hiding their weapons, they got back in a car, and my client drove them away from the scene, after which he helped them bury the clothes, and later on left the country and was on the run in Mexico. So In the years that followed, while my client was on the run, Beltran got convicted of murder. Alcaraz took a deal where he received, I believe, a 20-year sentence. And my client remained outstanding until one day he realized that he was tired of living like a fugitive, that he did not actually murder anybody. And so he did something I've never seen done before in any other criminal case. He contacted a priest, and with a Bible in hand, a photo of his new family that he started while he was living in Mexico, he literally walked himself on foot across the Arizona-Mexico border and surrendered to Border Patrol. After he surrendered to Border Patrol, which at first didn't believe that he was who he said he was, because after all, he was on the FBI most wanted list, he was brought to County of Monterey, where he stood trial. The first time the jury hung, and then our firm was hired for the retrial, and he was acquitted. And the reason why he was acquitted was because the jury found that he was not aware of the planning done by Beltran and Alcaraz. He was not part of the initial plan or the conspiracy, and he did not aid, encourage, or facilitate this particular homicide in any way. He literally was just sitting in a car, playing on his phone, waiting for his two other friends to come back from Taco Bell, and there was no evidence that he actually knew what they planned. Now, the government tried very hard in this case. The prosecutor was an extremely experienced, seasoned homicide prosecutor, and obviously he argued that how could you not know when you're sitting there? How could you miss on all the clues? How could you not see the weapons? How could you not see the blood afterwards? But we did a really good job. We brought in a psychological expert who talked about our clients, for example, attention deficit disorder, because our client was, like I said, a little socially awkward at that time. He was kind of a space cadet. He was not picking up very well on clues of what was going on around him, and so that really helped us with our defense. Now, he was totally guilty as an accessory after the fact, because he did drive them after the fact, even if he wasn't aware at that time.
And he helped them hide the evidence of the crime as well after the fact.
He helped them bury the blood-stained clothes, which I got the chance to examine in the evidence room. I still remember when they took it out of the freezer and they dumped it on the counter, and you could see the cloud of dust actually come up. I still remember how the earth, the dust, tasted in my mouth when they dumped it, and all of the dust went up in the air. But he was guilty. He was an accessory after the fact, but the government got greedy. You see, they didn't want to give the jury an option to convict him of what he was actually guilty. They wanted a homicide conviction, and so they overplayed their hand. They stretched their case beyond its natural credibility limits, and I do think it made a huge difference. I know certainly for me, because I lost sleep over that trial. I know I was talking to you on the phone while me and my partner at the time, in this case, Joel, were going through preparation for the case, but I really believe my client was innocent, because no one in their right mind would come back if they actually killed somebody and successfully escaped capture for as many years as he had. At least in my mind, I was convinced of that.
Now, we have seen some other examples of people leaving the country and coming back in the last couple of years here after the fact, but none of them stayed away as long as he did.
By all accounts, he had a good life. Yeah. He was working as a bouncer in a strip club. He competed in amateur boxing. He had a whole new life that he built for himself, and yet he realized, I'm an American citizen. I didn't kill anybody. I don't want to live like a hunted animal on the run, and that's why he came back, and he gave the system a chance, and the system proved itself, and he was acquitted of murder and ended up walking free after spending a couple of years in pretrial detention at the end. Now, you had an even crazier case, okay? So you had a case that touched on every single theory of liability, and then on top of it, also a doctrine known as provocative act murder. Now, the provocative act murder, for those who are not familiar with it, is a very interesting concept which holds that if a person commits an act, a provocative act, which by its nature is such that it's going to result in a response that's going to cost somebody their life, a person can be held liable for murder, even if they never intended for that specific victim to die. So an example would be, for example, if Roland and I go into a store to rob it, I pull out a gun, and the clerk, God forbid, shoots Roland. I could be prosecuted for Roland's death under the Provocative Act theory. And that's exactly what happened in one of the craziest stories that I've ever heard Roland tell. And that's the Solis trial, right?
Yeah, in the Solis trial, it was an interesting case because it happened at a quinceanera. And you wouldn't normally think there'd be a shootout at a quinceanera. This was a large quinceanera with several hundred attendees, humongous. They had multiple security guards. All the security guards were armed. They were all in black outfits, helmets, and surprisingly enough, they all had body cams on, GoPros on their helmets and stuff. So we got some interesting video from the security guards. So what happens is my client, Mr. Solis, and some of his friends, they're hanging out at the quinceanera, and of course they're drinking beer and having a good time. They got a little too drunk. The security guards weren't happy with them, decided to kick them out. Well, they all got in a tussle with the security guards, and before you know it, the security guards are spraying mace in all of their faces, and they're all crying and pouring out, not knowing what they're doing. And so it became a big brouhaha, and eventually Mr. Solis walked away from the quinceanera down a dirt road. As he's walking down the dirt road, he yells back at these security guards, he's going to get them, he's going to come and, mess them up really good. So
except he didn't do it himself.
No. So then he leaves. And he calls one of his friends, Mr. Iniguez. And Mr. Iniguez, being the person he was, he says, we can't stand for this. These security guards got to pay. Mr. Iniguez drove up in a truck. He had another gentleman that was in the front passenger side, literally riding shotgun. And
Armed.
Oh, everybody was armed. And then they talked to my client and some of his friends in a parking lot that was down the road. Hey, what happened? And it's unclear what happened after that. At that point in time, my client, Mr. Solis, got into the car and just drove away. Okay, he went to a party in Castroville or somewhere actually it was Greenfield now that I think about it. He goes to a party in Greenfield with some friends. He's drinking, he's hanging out, he's gone. Once he leaves, Mr. Iniguez is in a pickup truck. He says, I don't like these security guards. So they pull their guns and they drive down the driveway right to where the party is, and they start shooting at the security guards.
Now, miraculously, they're horrible shots.
No. One guy got hit in the butt. Okay, one of the security guards got hit in the butt. Okay, and however, the security guards, a fusillade of bullets are flying back at the truck, peppers the truck all over the place. And unfortunately, in the front seat of the truck, the young gentleman that was riding shotgun was hit.
Angel, I believe, was his name.
Yeah, Angel, I believe. And
ironically.
So, yeah. And so Mr. Iniguez left, and he turns around and sees his friend slumped over. And what he does then is he drives his truck back, and he goes and he takes the guy out of the front seat of his car. He puts the guy back in his car, and then he drives somewhere and goes, what am I going to do? He doesn't take him to the hospital. He puts him in his car, his own car, and that's where we get some accomplice liability. And actually, you represented Mr. Iniguez's father because he calls his father and asks for help, and his father comes and helps him after the fact with calling the hospital to report it. The police come, and unfortunately, Angel's dead. So the theory of the district attorney was that my client set this entire chain in motion, that once this event happened, as he's making the threats going down the road, he calls his friend up. He sits there and they all talk in the parking lot about what happened. And then Mr. Iniguez clearly goes down the road shooting. Now that directly is an overt act that he committed in shooting. And he was actually convicted of murder. Okay, yes. We didn't represent him. He was convicted of murder. And however, once again, the government was trying to convict Mr. Solis of murder.
And with your client, Roland, if I remember correctly, because it was a fellow accomplice that was hit, they were trying to go after him under the Provocative Act murder doctrine.
And they were using Provocative Act murder doctrine because Mr. Solis set this entire chain of events in motion. However, our argument was that he really didn't, that there was different events, that there was no conspiracy. Unfortunately, the jurors believed our presentation and the facts as we presented and the argument that I made to the jury, and acquitted Mr. Solis of murder, which was a good thing.
And he didn't get off scot-free. I think the jury was pretty deliberate with how they ended the case, because they did, I believe, convict him of an assault because they thought he was in it to see the guys, get beaten up. He just didn't want to see anybody die.
But at that point in time, yeah, anybody would rather get convicted of an assault as opposed to a first-degree murder, looking at a life sentence.
Now, question for you. Do you know what my client, Mr. Fabian Iniguez, was charged with?
Well, he was charged with accessory after the fact because he took the truck to the body shop to get all the holes fixed in it.
What's the craziest thing he was charged with? Do you remember?
It had something to do with the body.
Yeah, so
I don't remember that one. But
so
yeah.
the same prosecutor who tried your client was also the same prosecutor who was prosecuting my client. He was a very intelligent gentleman, and he really liked these sort of remote, legal theories. And so he went after my client, who was clearly guilty of being an accessory after the fact. He went after him with a kidnapping charge. Their theory was that while Angel was still alive, I believe the gentleman's name was Angel, while he was alive but doomed to die because he had a bullet wound to the head, he was not going to make it, my client allegedly takes him, drives him towards the hospital, but then he gets scared because of some past trouble with the law, so he doesn't actually bring him into the hospital. He didn't want to walk into the hospital holding a body with a hole, in his head, bleeding. So what he does is he parks the car in a conspicuous place. His wife follows him, so he gets in the wife's car. They go to a payphone, and then he calls in an anonymous tip that there is a victim located there. And then thereafter, what he does is he helps his son escape to Las Vegas. They help fix up the car, and
classic accessory after
the fact conduct, which would have quickly resolved the case. But the DA really was testing out the theory of kidnapping because the body was moved. The gentleman was still alive, though really completely non-functional and could not have been saved, and was therefore not capable of giving consent. So since consent wasn't given and movement happened, the DA felt this was kidnapping. Ultimately, we had to fight it for a number of months, a number of motions, and the kidnapping fell off. And this remained what it always has been, which is a classic accessory after the fact. Somebody calls their dad, somebody calls their mom and says, please help, I got myself in trouble, please help me. And there's a learning lesson in this that when in doubt, you got to do the right thing, not the wrong thing. Otherwise, you get everybody in trouble. Now, if you guys have been watching our videos, you know that Roland and I really love to end every video with a list of some helpful suggestions, some tips and tricks, things you can do to protect yourself if you ever find yourself in trouble and to stay out of trouble. So with that, Roland, take us to number one.
So number one is you really need to understand the law of accomplice liability. I mean, if you're talking about committing a crime with other people, make sure there's no overt act committed. Make sure that you're not actually doing something to further the conspiracy. If it's just for fun and you're laughing about it, that's one thing. But make sure that you understand what the rules are. That once you talk about it, once you take some overt act, you're on the hook. And it's that point in time where you might have to withdraw and be loud about it.
Number two, avoid being complicit. Do not participate in any discussions online, on the phone, or in person with other people when the topic of conversation has to do with planning some sort of criminal act. It may seem in good spirit, it may seem to be in jest, but if something, God forbid, happens, your complicity in these discussions could be interpreted down the road as you agreeing with the objective and therefore could potentially expose you to criminal liability.
So number three is, if you're involved in any discussions, even if in jest, avoid putting anything in writing and also avoid recording any of this information. Don't make a YouTube video of yourselves agreeing to do some crime or planning on some type of crime, even if it's in jest, and don't put anything in writing. Remember the classic episode from The Wire.
Nigga, is you taking notes on a criminal fucking conspiracy?
You do not want to take notes on a criminal conspiracy.
Number four, be careful with your associations. Some people are magnets for trouble. You know that some of your friends or some of your associates may probably lead you down the wrong path. So be careful with who you're seen with. Be careful who you're hanging out with. Some people are nothing but trouble, and you're better off staying away from it. Otherwise, they're going to be talking about things, talking about doing things that you want to have no part of.
Number five, don't assist anybody with hiding evidence or evading capture. I mean, if your friend calls you up at 3 o'clock in the morning asking you to meet him in a blank field with a shovel, you know nothing good is going to happen. Make sure you ask questions, even if it's your loved ones and they're asking you to pick them up at a weird time in a weird place. make sure you ask the appropriate questions. Do not just go blindly into it. And if you find out there's some kind of crime committed, really, before you step into it, make sure that you know what you're doing.
Number 6, if you were unfortunately involved in some sort of criminal activity and you really feel like reaching out to your friends or loved ones for help, please don't. All you're going to do is just get somebody else in trouble, because if they actually help you hide the body, repair the damaged car, or avoid capture, they're going to be sitting in the same courtroom next to you being prosecuted for being accessory after the fact. And if a person is in the same courtroom with you being prosecuted next to you, they're not going to be able to provide you with emotional support, family support, or financial support that you're going to need after having committed a crime.
Number 7, avoid online discussions. I know it's fun to go in a Facebook chat group, Substack, Reddit forums, and you're going to talk about how to plan things or do things, or if you even have gripes against people, doing a list of your gripes against people. Please avoid that. That leaves us a direct record of any type of involvement. It's not a good idea. Stay away from that. That's how you stay out of trouble.
And Roland, when you're saying this, I can think of so many cases, gang cases, homicide cases. One of the first things that we look at when we're getting copies of criminal discovery in this case is, what are the communications between all of the involved parties? What are kids saying on Snapchat? What are they exchanging messages on Facebook, Instagram, texting each other? And just like you said, it's enemies list of things they're going to do, talking about their gripes, talking about their motives, talking about their biases. And that's just a recipe for disaster, because police officers are going to get your phones, they're going to get your Facebook records, they're going to get your social media records, and they're going to speak for you, even if you manage to keep your mouth shut and not say anything.
Number 8, please just keep your mouth shut. Don't provide evidence to anybody. Don't talk to your friends. Don't do online discussions. Don't take credit for anything you've done. Even if you didn't do it, don't take credit. And above all, if the police call you, they're not coming to be your friend. They're coming to get evidence. Keep your mouth shut. Don't talk to the police. Don't talk to anybody. Just stay silent.
Number 9, if you get the sense that police are looking at you as a suspect, if you know that you have been involved in something that you shouldn't have been involved in, if you have been a witness to these types of discussions in chat forums, in text messages, in social media, and you are scared about the kind of things you're seeing and how that could reflect back on you, please consult a criminal defense attorney immediately. If you contact a criminal defense attorney in advance, you will learn from that consultation exactly what your legal duties are and what your liabilities are. And if you don't do that, you could inadvertently incriminate yourself or make critical mistakes that could make convicting you a lot easier.
So, number 10, always maintain a clear exit strategy. Remember, if you're in a criminal conspiracy, you need to make it clear and unequivocal by your words and acts that you are no longer a member of the conspiracy. And if you're involved as an aider and abettor, it's very important that you have to do everything you can to stop that crime from occurring.
We really hope you enjoyed this video and learned something useful from it. We really appreciate you clicking that like button, subscribing to our channel, and until then, we hope that you stay out of trouble.